Probate expert. And this is our Thursday edition of, or Thursday probateweekly.com podcast. We do every Thursday at 4 p.m. Pacific, 7 p.m. Eastern time, and whatever it is in the middle. We get together real estate investors, wholesalers, real estate agents, attorneys, vendors, and talk about all things probate real estate. Now, it's meant to be participative. This used to be done live. And so we'd love to answer questions. You can either, if you're on the Zoom call, you can raise your hand or put a question in the chat box, and I'll get to those questions first. We also stream this live to YouTube and Facebook and LinkedIn. And so if you're there, you put your questions in as well. I'll do my best to get the questions on our call as well. It's meant to be interactive, and I prep the guests that way. So just a quick introduction. I'm really excited today. Those of you who know my story know that I've been in business a long time, and like a lot of agents had done some probate real estate. I really launched my all-in probate lead generation about 3.5 years ago. And my technique was to go to the court every day, both to learn the process and to meet the people. And I always look for the attorneys that were better than the average bear, because that's who I wanted to work with. And the ones who were less than average, I actually offer my services to them as well. Our guest today is an attorney who I happened to meet while I was in court and saw him in action and said, wow, I'd love to someday be able to work with him. He also does a great job of educating the public, not just on probate, but how to avoid probate through various estate planning issues. And so we'll get into talk to that about him. Please help me welcome William Hayes from the Hayes Law Firm here in Pasadena. Mr. Hayes, thanks for joining us today.
Thank you, Bill. Thank you for having me.
And I love that picture over your shoulder. I said that last time I saw you, but I'm a sucker for historic pictures. And old Los Angeles, was that like 1959 or something?
I would imagine it's the late 60s. I bought the picture because it had my first car in the picture, a 58 Chevy Impala. So I had to have it. But I'm guessing maybe early 60s.
I love that shot with the downtown. Back when the law in Los Angeles was the city hall had to be the highest building in the city, I think until about mid 70s or something.
Right. Yeah.
No longer the case. So welcome. Before we jump in too much, give us a little background about where you grew up, and then how you got into the practice of law.
Well, I'm originally from Chicago. I moved here as a teenager. I went to UCLA Law School, and I joined an entertainment law firm out of law school. It was a boutique firm, but we represented many of the major film and music celebrities. One of those celebrities was an actress by the name of Susan Hayward. And Miss Hayward had been the Academy Award winning actress for the Best Actress category. When she died, she was a client in the firm. When she died, her son, who was a friend, asked that I handle the probate of that estate. And that was the beginning for me in probate, because of course, up to that time, I had been doing just music and film contract work. But this was kind of a calling for me. I really enjoyed working with that family and seeing the immediate impact that I could have by working with them. And I've been doing it ever since. So in that firm, whenever anyone died after that, I was the first person to raise my hand and say, I'll do it.
Wow. Well, it's a very impressive story. Other than the UCLA part, all that is very impressive.
Well, my wife went to USC, so maybe that'll balance it out a bit.
You're a family. You're part of the Trojan family, then. Okay,
that's it. Welcome. There you go. Yeah.
And that's what it is with us. If either party is part of the family, then you're in. So we're very inclusive. So describe your practice today. I know you do estate planning as well as probate work, and I think some litigation as well. I think I've seen you in court litigate matters. Or what are the ranges of your practice today? Yeah,
we do limited litigation. We pretty much limit our practice to doing trust planning, estate planning, various types of trusts, of course. Not only the living trust, but whether it be insurance trusts or charitable trusts, life insurance trusts, we do that, all of that. We seem to have lost the screen. Oh, there we are. And we also do trust administration. So, of course, after you do the trust, it's even though it avoids the probate process, there are some moving parts that have to be dealt with after someone becomes a successor trustee of a trust. And oftentimes those people will need some direction, and that's where we come in. I also do Medicaid planning. Medicaid planning really came about after the increase in the estate tax threshold, which helped a lot of people who are high net worth people avoid the estate tax. When it was raised to 12 million, well, currently it's $12,060,000 per individual before the estate tax applies. And as you know, it's going to sunset. That's going to change again back in the year 2026. It will go back to 5 million. But we got into doing Medicaid planning because the market for estate planning became that much narrower because most people didn't have a need to do too much planning to avoid the estate tax. Medicaid planning is about planning for people who are anywhere from low income to upper middle income. How do we plan for that person to help them preserve their assets and qualify for Medi-Cal? Because one of the problems that I have seen more often than I care to think about, it had been over the years seeing people who had lost their homes to Medi-Cal, or the families had lost their homes upon the death of a Medicaid recipient. So what we do is show people how to create irrevocable Medicaid trusts into which they can transfer their assets and have them still be able to qualify for Medicaid. So my focus went from helping people who were wealthy avoid the estate tax to helping people who were middle class and upper middle class avoid losing everything. And I feel a better sense of satisfaction in doing that. And of course, we do probate.
You know, it's interesting. When I look at your website, and I know, I've researched enough attorneys. I know clients will tell me names of attorneys. I see website with a similar layout, and I see 4 categories. And so in some attorneys, I'll see like, civil litigation, estate planning, drunk driver, and criminal. And I go, how could you do 2 of those well? And you do have 4, but they're all really at some level interrelated, meaning the estate planning will avoid the probate most of the time. Sometimes something comes up. The probate is if you did an estate plan, but all these are kind of interrelated to a degree. So it seems your focus overall is about intergenerational transfer of assets and how to protect your assets. Is that a fair summary?
That's a fair summary. I mean, there's a certain synergy that happens between those 4 categories. So I don't think I'm veering too far off the path and working in those areas. Yes.
And it seems to me that the most successful attorneys from a business point of view, I find, are always the ones that specialize rather than having a broad net and, well, I want to get this deal or I got this, so it comes to me. I find that without a doubt, the ones who are really, really good have a very narrow niche. If you know what that niche is, it fits, great. If not, you're not the right person. So everybody who watches this, I get asked all the time on different chat boards and such, oh, we need a probate attorney in this area. And there'll be like 5 different answers. And it's like, but you even know what they need. How could any of those answers be right? And in my experiences, odds are none of them are right. You're better off finding out what they need, be more specific. So let's backtrack a little bit, go to the beginning one, estate planning services. And I know you, and again, another reason why I reached out to you was I saw that you do a steady diet of education in this area to help people understand the importance of estate planning. So I don't want to have you do your whole estate planning seminar for us, but give me like a brief overview of why is it important for somebody to plan for estate if they're healthy and they have money and they're liquid and everybody's happy and there's unicorns dancing and rainbows in their backyard. Why should they take time out of their day and spend money with an attorney to do estate planning?
Well, they're healthy today. And as we know, everybody is going to die at some point. You've heard the phrase, the death rate in California is still 100%. Well, people need to plan for that. Yeah. And even though you're healthy today, statistically, the Department of Health for the United States says that 7 out of 10 people over the age of 65 will have long-term care health problems. And that statistic is quoted across not only by the Department of Health, but by all of the insurance companies. 7 out of 10 people will have long-term care problems, and 40% of that number will wind up in nursing homes.
Well,
So when I think about planning, I know that you can't really have a complete estate plan unless you have planned for that issue, because it's not just a possibility, it's a probability, right? So when I talk about doing estate planning, not only do I focus on it's just creating a trust and the associated documents, we need to talk about how do we protect this person if they become one of the 70% of people who have long-term care health problems. Now, there's a distinction to be made between long-term care health and your general health issues. Kaiser and Blue Cross will pay for hospital visits and doctor's visits. But if you have a chronic, ongoing health problem, they may well not cover that. And Medicare will only cover that for up to 100 days. So you need to have a plan that deals with that issue. How are you going to protect yourself if you don't have long-term care insurance? What are you really going to do? Are you going to just leave yourself and your family saddled with these humongous bills from hospitals that you really can't pay? Or are you going to have a plan? So I practice a specialized form of estate planning referred to as elder law. And for a large degree, what elder law is about is how do we protect people as they age so that they can really have a reasonable expectation of enjoying golden years. And given those statistics, if you haven't had if you don't have a plan in place, you may well not enjoy those years. So I don't know if I answered your question, Bill, but yeah.
No, I think that the answer always is, if you don't have a plan, the state of California has a plan for you. You may not like their plan. It looks a lot like the DMV. It's just not as customer service oriented as the DMV, but there's a plan there for you. If you plan ahead, you can make your assets go further and choose your options. Part of estate planning is also,
if you're like Chuck Simmons, you're going to live forever. I just saw his message go to way to go, Chuck.
Chuck's a bit of a smart aleck, so I had to give him a little smart aleck answer back. If you're not on the Zoom, we're chatting back and forth here while Bill's talking. Well, Mr. Hayes is talking. I didn't mean to get caught on that. Okay, I felt like the teacher caught me chatting during class. So I also know the estate planning is for when you pass, how the assets are, and then you talked about how and the costs and such, but also it has to do with planning for if, God forbid, you're incapacitated. Like, who makes those decisions in your life? I know recently my daughter had her first grandson. And while we have great terms with my son-in-law and daughter, and we have great terms with his parents, they're fantastic people, they live in New York. I can imagine, even that we'll get along, deciding who makes decisions for a child could be very difficult. Those stresses come out under time. So how does estate planning help protect the children for somebody who's perfectly healthy today and financially sound? What are some of the tools you have to help children get protection in case something happens to the parents?
Well, of course, for younger people, oftentimes it's the children that is the great motivation. That's what motivates them to consider estate planning. And that, and the fact that they may purchase their first home or something like that. But if you are a young parent and you have children, you certainly want to make sure that if something happens to you, the people that you feel will be best in handling their needs is appointed to do that. Right. And in your trust planning, you will designate that person. And you might also set up a fund to make sure that the financial needs of that child are met. But if you don't do that kind of thing, of course, you wind up in probate. And it becomes problematic to get that money immediately. So you want to have a trust in place so that there's no delay. There's no time lapse between your disability or death and making sure that the child is well taken care of.
No, recently you were a guest speaker by, I want to say, the Humane Society for people who have non-human errors that they want to have taken care of after they leave. Right. A way to set money aside to do it. Can you kind of briefly describe that as an option and what that looks like?
Well, when we do a trust, we create various types of sub-trusts. And one of those sub-trusts, of course, is for pet owners. And many people are as close to their pets as they are to their children. And they want to make sure that if something happens to them, that the pet is well taken care of. So we set up the sub-trust. They designate the person who's going to be in charge of that trust. It might be that they even have a trust protector to make sure that the pet is well taken care of and to make sure that the money that they leave for the care of the pet is doled out in the way that they feel it should be done. So it's really interesting when I do the presentations for the Humane Society to talk to pet owners and see the love that they have for their pets. And I know many of the people here are probably pet owners, but the reality is that in the state of California, a pet is not considered anything more than just property. And so you cannot have just a will in which you leave your money to a pet. You know, you have to set up an apparatus that will take care of the pet. And that's what I try to convey to people when I do these presentations.
And it's, I'm not a pet lover. I mean, I'm not a hater. I have a busy life and I don't really appreciate.
You don't have the
pets.
time, sure, yeah.
Well, whatever. So, but it is amazing how to a group of people, a percentage, it's so important to them. And when I learned there was such a tool, of course, if you love your dog or cat or whatever your pet is, why would you not do this as a way to maintain them? I know my wife, I tell her all the time, the day she's gone, on the way home from the funeral, I'm taking that dog to the pound or where you take dogs to donate them. And she starts yelling at me. But if the trust said I had to take care of it, I guess I'd have to take care of it. So there's some protection you can build into the process.
Yeah. Well, there's as you have seen, people like Leona Helmsley. You remember that story? Yeah. She and her husband owned the Empire State Building, and she left $20 million for her dog, whose name was Trouble. But the amount was knocked down by appeals, and I think ultimately there was $6 million set aside for the pet, which I could live with that.
I don't think I have that much coming to me that we'd have to worry about setting a new legal precedent, but still.
Right.
The dog's on very thin ice if my wife's around. I'll just say that for the record.
You might slide the dog across the ice into a hole, right?
I don't know. I'm not cruel. I just, I'm not that way about it, but
yeah.
Okay. So that is, and so that kind of describes the estate planning, and within estate planning, there's a bunch of ways you can go: guardianships and conservatorships and protecting children and people incapacitated and inanimate or animals, I guess. I guess also part of estate planning is leaving money to charities that you choose to. How does that get built in? If I came to you and said, when I pass, I'd like to give money to these charities, is that just something you build in gifts? Does somebody make those decisions? How does that work?
Yeah, well, with most estate planning documents, there's oftentimes going to be a template for the document. I mean, nobody does a trust from scratch. No attorney does that. You wouldn't have the time to do that. So the same as occurs with our office. So we have language that we have used that we feel passes the test in terms of protecting the client and the distribution that they want to make. But we will generally set the language up, the terms for how that charity is to receive the distribution. What happens if the charity is not around? Generally, that means it's going to a like charity, a similar charity. And we have the language that will allow the successor trustee to implement the tax deductions that may come for that contribution.
Yeah, so estate planning includes a lot of details, a lot of possibilities. It's a very powerful tool to kind of attempt to kind of guide things. And in fact, Linda Heim brings up another interesting point. Thank you for pointing out, Linda, is a special needs trust, right? They're different.
I saw that from Linda, yeah.
And I know there's a whole area of law there, right?
Sure it is, yeah. And we do, of course, do sub-trusts for special needs. I mean, we don't often, if we're doing an estate plan for someone, we don't try to have them do a separate special needs trust unless unless the facts dictate that it's necessary. But in most cases, we do it as a sub-trust to the person's living trust. Mm-hmm. And of course, again, there you designate who's going to be in charge of the special needs trust. If you're creating a sub-trust or someone else, the special needs subtrust, you can also designate what happens to the money if the special needs beneficiary were to die. And but unlike there are other types of special needs trusts, for instance, what they call first party special needs trust, in which, let's say, the person became a special needs person as a result of an accident, and they received a large amount from an award, a damage award. Well, that money can be put into a special needs subtrust. That person who's the special needs person can still receive benefits from the state. But when that person dies, those special needs funds have to be returned to the state of California to reimburse the state for any monies that it put out on behalf of that special needs person. So that is to be distinguished from the third party special needs trust, which is where, say, a parent or grandparent or friend, whomever, creates a trust using their own money. Well, in that case, they can designate who the recipient will be if the special needs person dies, whereas as opposed to the first party trust, where the person got the money from an accident or something, well, then that money has to be returned to the state of California for reimbursement.
And so all these things are, none of these things are important until they become important. And you're
Exactly.
sitting in court and there's a court appointed attorney, there's a this attorney, that attorney, there's fees coming out. It's amazing how when there's no plan, I would say it's chaotic, but it's certainly bureaucratic at the least. And so what you're setting up is to try to minimize the bureaucracy and kind of push things down a path of known solutions.
Right.
Okay, so that's estate planning. Next, trust administration services. So this is a case where somebody has a trust, and I've seen this personally, where some of the trust passes and they have a house. Okay, you can sell that, but they have other assets. Some are in the trust, some are not in the trust by title. There's personal property, there's stocks, there's bonds, there's bank accounts and such. And somebody has to get the records to file the tax returns. What does a trust administration service look like to a family?
Well, of course, you start by marshaling the assets. You want to know what the estate has, what the trust has. Of course, there will be some assets which are outside of the trust. For instance, when we do trust planning, we never put things like, well, not often do we put things like IRAs or annuities or life insurance policies or retirement plans into the trust, because those assets generally will have designated beneficiaries. They've named who they want to receive those assets. But what we do is make the trust the contingent beneficiary of that asset. So that money, while it belongs to the deceased person, it's not something that's going to be administered in the trust. So we want to find out in the trust what the assets are that are in the trust and what the liabilities are for the deceased person. And the obligation of the trustee is to make sure that all creditors who are supposed to be paid are paid, and that all taxes are paid. And you want to also give notice to all of the beneficiaries, statutory notice to all beneficiaries that there is a trust administration occurring, and that they have 120 days to object to any of the terms of the trust if they choose to. And if they don't, they are going to be barred from doing so. So we have the trust assets determined, we have the liabilities determined, we've given notice to everyone. If there are assets like real estate being passed, we of course want to file for the appropriate exclusions and whatnot. And after we've done that, we of course have to do an accounting for the trust.
That's often a challenge.
That's often a challenge. You're right. You're right. But it's the place at which you want to cut people off at the pass in terms of having ongoing finger pointing, which happens in these situations quite a bit. Now you want to be able to say, okay, here is the accounting. You now can tell us whether you see anything in the accounting that you object to. Now, even though we do the accounting, and there may be people who object to the accounting, you cannot use that as a basis for not distributing them to them designated share of the estate. Okay, you can't hold their distribution hostage until they approve the accounting. You still have to make them their distribution, but you have the right to withhold a reserve for issues that may come as a result of any possibility of disputes, legal disputes. So we may say, okay, here's your distribution, everyone, but we are withholding $50,000. And we're going to hold that for a certain period of time to make sure that there are no litigation issues that come up. And you can either do it that way, and generally you can hold it up to 3 years for 50,000, or you can file a petition for the court to approve the accounting. And of course, that's a quicker way to do it.
Michelle asked a question about what's the difference on creditors being notified when there's a probate versus a trust?
I'm sorry, once again, Bill?
Are the creditors notified in cases of probate versus trust? How will creditors know about the death and the opportunity to collect in a trust situation?
Yeah, the only thing that we do is make sure that we go through all of the paperwork of the client, of the decedent.
Okay.
And make sure that we don't see anything that we check on every creditor that we are able to locate in reviewing the decedent's documents.
But there's no notice process. It's not like a probate where they're put on
No,
notice.
it's not like a probate. There's no requirement that you publish notice in the paper or anything like that.
So one of the advantages in the sense is that if creditors are paying attention, somebody passes, the assets can all be distributed before they have a chance to raise their hand and say they're owed money. Okay, good. So I guess we crossed over that.
Yeah.
And somebody asked, Linda asked, do these rules apply to California? Mr. Davis, you're licensed here in California. Are you in other states as well?
No, just California.
So I think, Linda, to answer your question, I'd say he's speaking as an attorney here in California, not giving you legal advice, but giving you some education and some theoretical explanations. But these principles are pretty much true. I've interviewed attorneys now in about 10 different states, and it seems like the rules are fairly similar in all states. They all seem to kind of copy each other or work from each other. So I'd say these are basic principles that are true. But if you're in a different state, you should check with an attorney that's licensed in that state. Great questions, guys. If you have questions, put in the chat box or raise your hand in the Zoom call. I'll do my best to get to you. If the trust states that the sole beneficiary is the son of the decedent, and there's no other children, no other spouse, will the executor have to send those letters to other family members, like brothers and sisters, nieces, nephews? Okay, so I think the short question is, in a case of a trust, if the sole beneficiary is the son of the decedent, who else does he have to notify? Assuming he's the only beneficiary, is there any reason why we'd have to tell anybody else?
Yeah, you want to be able to notify people who might be potential descendants of the decedent. So let's say that there's a son who survives, but he had a brother who died, and there are nephews and nieces from that deceased brother. Well, you need to give notice to those people too, because even if it's a situation where the trust has indicated that that person is to be disinherited, they still need to be notified so that they will have the opportunity to file an objection, because they may want to allege that there was undue influence used in the creation of the trust, or that the trustor, the trust creator, was mentally incompetent at the time. So you can't just ignore them as though they don't exist. They need to at least be given notice.
That's an interesting concept. So the fact it's a trust, the privacy will not prevent somebody from being disinherited to protect the case of fraud, which is common, right? The caregiver or the nurse in the last week has them sign a trust that she's gonna get everything. And now and it says, she gets it all, and but she has to notify the son anyhow, or the heirs, to give them a chance to say, where'd this trust come from? We didn't hear about it. Dad was sick then, dad was senile then, dad was not in capacity then. And so they will have to give notice to at least pass that test, I guess, that there wasn't something going on. That's a great question, Nikita. Thank you so much, from Houston. Very good. Is a K-1 sent out every year? So the K-1 comes to the family on investments or the assets that they have. I'm not sure what that means, Linda. I see your question about K-1, but I'm not sure what you're asking. Is the K-1 sent out every year? I guess if you're in a trust that has assets and there's income, and there's recipients of the income, they would get a K1. And if the trust is receiving income, they will receive K1s for those investments. But I'm not sure how to answer what your question.
Yeah, I think if it's an ongoing trust and the trust has not divested itself of those assets, then yeah, you're still going to have to file every year.
Okay, and then so the kid follows up and says, no, if the son is the only child, and again, the kid, I think Ms. Hayes' answer was, if he was the only child ever, there's no other children, then no, there'd be no need to know somebody else. But there's a case where maybe there were two sons, one died, but that other son had kids, they would have to be notified, for example. So just because people have passed, if they have children, then they might be heirs other than the verbiage of the trust. And I think what he's pointed out is you can't avoid telling people the status just because you don't want to tell them. If potentially they would have an objection, they have to be notified. Okay, income and property, there's income and debts. Okay, so yeah, Linda is saying on an income property, there's income and debts, so you have to do a K1. Here's the thing, he has to send it out because he didn't know what the excess would be for 2020. I'm not sure I understand your question. On the income property, there's an income and debts. Trustee thinks he doesn't have to send it out for 2021 since he doesn't know what the expense would be for 2022. I'm not really sure what that means, Linda. That's a little more complicated, I think, than we get into. I think I'll have to defer you to another time on that one. Unless you want to unmute yourself and you can explain it.
It sounds like a question that it's more of a tax question.
Yeah.
Trust administration question.
Yeah, I mean, there's a question about you have the same responsibilities, I think, to file as an individual, right? If you receive income and you have to file an income on that, an income tax report on that income, and if you distribute income, then you have to file information there as well. But I'm not
the
sure.
Trustee would have to file a fiduciary tax return, the 1041 tax returns.
Right. Linda, I don't know if you want to.
You'll have to file the K1s. Yeah.
Okay. And if you want to unmute yourself and jump in, I'm glad to let you do that, but I'm not sure I'm following the question.
Yeah, I'm one of the beneficiaries on the trust from my mother, and it's fourplex. So there's income coming in and then there's debts going out. And my brother is the executor trustee. And when I asked him about the disbursements for 2021, he said he didn't do it because he doesn't know what expenses there's going to be for 2022. So like if we have to put a new roof on or something like that. But so my understanding is every year he needs to do it. He can't just say there's a projection of extra expenses for the following year. Is that correct?
I would be inclined to agree with you.
So, just because, I mean, we do need to put a roof, but does that mean he doesn't have to give disbursements in 2021? Because.
Well, I think that would be, if he's not doing it until 2022, that's something that applies to 2022.
Exactly. And he's still we're still getting income for 2022. So, right. Okay. That's what he thinks. He thinks he doesn't have to because there's projected expenses.
Well, has he been talking to an accountant? I mean, I think an accountant.
I don't know. That's what he's telling me. And
yeah.
But of course, there's still income coming in. But
sure. Mm-hmm.
That's another.
My father used to say, you can write off anything you want until the IRS audits you. It makes you prove it up. Then you have to figure out.
Yeah, that's. And I mean, all of the beneficiaries are thinking, where's the K1 disbursements?
Right. Yeah.
And can I ask you one more question? If a person such as myself wants to get bought out, is it a simple thing to be bought out of it, or do I have to go to an attorney to do that?
No, I mean, if the other beneficiaries want to buy you out, there's no need to get an attorney involved. I mean, not necessarily. It depends on how complex the issues are, but
no, they don't want to buy me out, but I want them to refinance and buy me out. This is just too much family drama.
Yeah, well, a lot of that will depend on what the discretion is that is given to the trustee. I mean, if the trustee can decide to sell or keep or refinance, and that's trustee is given reasonable discretion, then that's what's really going to control here.
If he does nothing, it's okay too. I mean,
well, he can't do nothing if it's not in the best interest of the trust. He has to do what is in the best interest of the trust. That's the ultimate light that he has to follow. What's in the best interest of the trust?
Okay, thank you.
Sure.
So we've had a chance to kind of talk about, okay. So we talked a lot about your practice.
Mhm.
A lot of people on this call are real estate investors, wholesalers, or like me, real estate agents, where we stumble across somebody who needs some help, and the help involves legal services. Can you describe a little bit, what is it like for you personally in your firm, working with real estate agents, working with investors? Is that a common thing? Is it not common? If so, what does that look like?
It's very common. I mean, because most of the trusts will contain real estate. So if the trustees decide to sell the real estate, we're always going to work with different real estate agents.
Do you have real estate agents that come to you when customers are looking to sell the property? They don't know how to manage it in the trust. Maybe the attorney who wrote the trust isn't available. Do you get, do you get involved at that stage of the process, or you talk about just your clients who need to sell property? Or I imagine there's some of both. But do you get cases where real estate agents have a deal, but the family can't move because of some document, paperwork, legal issue? Is that part of your process?
Yeah, that happens too. But primarily it's because my clients have a trust and they're deciding to sell the trust, particularly in light of what happened with Proposition 19 and the exemption going away largely for parent-to-child transfers. So because they don't have the same full exemption that they had before under Prop 58 for parent-child transfers, many children are more apt to just sell the property than they used to. So yeah, I get involved at that point. Not so much that I get calls from real estate agents because of glitches in a transaction, but sometimes it happens.
And how do people typically come to you for estate planning services? I know you do a lot of outreach and education. Is that your primary way, or?
Yeah, well, it used to be that I would do a lot of seminars for companies, organizations. I would do presentations of hotels and so forth, at libraries. Since the pandemic, I do everything on the web. And we regularly have presentations. We have them every Wednesday at 6 and every Saturday at 10 on estate planning. And sometimes it'll be a presentation on Medicaid planning or trust administration or probate. And we do a lot of frequently asked question spots that are all over the internet, I think. We do a lot of mailers as well.
There you go. So his website has a list of a number of the upcoming webinars. I've been on a couple of them. They're great, interesting topics. I think you really get in some niches, which I find interesting to explain. I know I've learned a lot watching what you do. So, and that was really what prompted me, quite frankly, the first time I reached out to you after we met, was it seems like you're so focused on educating people to work with you. I think there's a lot of ways to get people to want to work with you.
Right.
I'm not going to take pictures of myself in a bikini on the internet just to get attention.
That would get attention, Bill.
It would, but not the kind of attention I want. And but I think, like you, I've often tried to work on educating my marketplace so that I can be perceived as an expert and people can draw their own assessment based on what they see. And I think you've done the same in a really professional way. So I know I appreciate it. Chuck says, okay, no.
Is that
Chuck,
me?
So
Algorithm.
what is that? Algorithm. I'm not sure what that means. Does Al Gore dance or something? I'm not sure what that means. I'm a little out of the popular culture, I think. So, okay, last call for questions. Raise your hands or the chat box. Feel free to put a question. Raise your hand in the Zoom call if you're watching on the live stream. I see a bunch of people on our live stream. We've got a nice number there on the YouTube, especially. Thanks for checking in and watching us. Feel free. Last call though for questions. I've been under the weather a little bit this week, and I actually caught the coronavirus for the first time in this whole cycle. So I'm definitely dragging a little bit myself, but thank you for that's a great question, Sherry. So how do you get, this is a question from a real estate agent, I believe. How do we get ourselves in front of attorneys to get more probate business? I'm willing to launch this part of my business. So if let's say it wasn't here in LA, let's say you're advising a real estate agent in another county or you weren't in the business, and a realtor came and said, I see the market for probate as a real estate agent, and I want to service it. What advice would you give them to earn the faith and confidence of attorneys to refer them to business?
Yeah, that is a good question, because we do get a lot of people who approach us about wanting to refer business to them.
Mhm.
And I think the best way to get the attorneys to want to work with a real estate agent is to give them something rather than just approaching the attorney about, I sell real estate, I do probate real estate and so forth. You have to give them something that will catch their attention. Otherwise, you'll be put into the trash can. So if there was one person who used to send me out articles related to real estate and probate and real estate and trust administration, that caught my attention. And you can believe when that person ultimately did call me, that is somebody that I had already developed a sense of respect for, and I was willing to talk to that person. But quite honestly, more often than not, I don't return the calls, just to be honest. So you need to come up with something that is going to make that attorney distinguish you from everybody else who sends a letter saying, I sell probate real estate. Because we get those every day.
So what might some examples be of that, if you don't mind sharing? Not that we should all line up at the Hayes Law Firm with a box of candy and flowers, but what might a box of candy and flowers look like? I know, for example, in the old days, my father was an attorney. And in the old days, when I was in real estate, I was in the mortgage business. I started. And I also solicited business from attorneys. And so he said, almost any attorney, if you call them, invite them to lunch, a nice restaurant, they'll sit down with you and have lunch and you'll meet them. Don't ask for business, but start the relationship. And I always felt like that was such a effective tool, though these days with COVID, that's a bit of a challenge and people are more hesitant to go out. What would be appropriate things to give an attorney to help them so that they can show that value? You have any examples in mind?
Well, I mean, as I said, articles that
information,
intersect probate and real estate, or trust in real estate. Okay. And as far as inviting people out for lunch, I had someone recently who invited me out to lunch, but the lunch came via DoorDash, and nice. So our meeting was on Zoom. Nice. So if you tell someone, I'm going to have lunch sent over from Fleming's Steakhouse or something, not many attorneys are going to say no. Why nice. Not? Yeah. And at least you'll get a chance to speak to that person.
Exactly.
Yeah.
Exactly.
But what happens after that, of course, is up to you, because there's also the reality of once anybody gets back into their lane,
right,
they're not going to really think about you anymore. Right. So from that point, you have to have some kind of drip campaign to stay in front of that person and to reach out to that person periodically. So hopefully you bonded with them during that lunch, so that when you make that call every 2 or 3 months and say, hey, Joe, how are things going? They'll take the call.
Right.
Yeah.
You have to develop that relationship. It's not a one-time thing, right? Your legal practice isn't for sale with one steak from Fleming's. It's going to be a few phone calls as well.
2,
right?
maybe, yeah.
Eric asked a question that if somebody has a living trust on a property, is there any way they can revoke it? Like the property is vacant and the recipient, the life estate hasn't done anything in it. So we see this where people have a trust and they say the trust are going to give it to so-and-so is living there, but it's decrepit. And I think the answer is that there's 2 types of trust. There's revocable and there's irrevocable, correct?
True enough, yeah. And most people, of course, have revocable trust, what people refer to as the living trust. But if the person who created the trust has died, and the beneficiary is not showing any interest. I had a situation not long ago where someone had moved into property and declared to everybody that, you know, I'm living in this property and I'm paying the taxes. Well, basically what that means is that they are taking possession of that property through what is called adverse possession. And if they stay in that property for 5 years, living, the phrase in most legal cases is referred to as living in the property in an open and notorious way, meaning you're not shy about saying, this is my home, and you pay the taxes and whatever other maintenance costs there are, and you do it for 5 years, it's going to be hard for that beneficiary to come back 6 years later and say, hey, that's my property. So.
Right. So the answer then is, with the living trust, by definition, a living trust is a revocable trust. You could revoke it. It's an irrevocable trust. And when is an irrevocable trust more about shielding assets? Is that the distinction?
Yeah. So for instance, in Medicaid planning, when we do a living trust, we include in our trust something that we refer to as Medicaid triggers. And basically, without going into detail, it's a way to enable and authorize the person who is in the trust, or who is in charge of the trust when the trust creator becomes disabled, to be able to move assets out of that trust into an irrevocable trust. The living trust is revocable. You want to move it into an irrevocable trust. You put those assets there, but you have to do it in a very precise way. You can't just take the property, take the assets in mass and just transfer them. You can't take $100,000 and say, hey, I'm just transferring it into this irrevocable trust. They have a process for transferring assets in California when you're doing Medicaid planning that will allow you to transfer those assets without causing the potential Medicaid recipient to disqualify themselves. So you have to transfer the assets in increments under a certain amount. The same with real estate. If you're transferring real estate and you want to get it out of your name, let's say you have an investment property. And I say investment property because if it's your primary residence for Medicaid planning, that property is considered exempt. So you don't have to worry about it. You can take your primary residence and just put it into the Medicaid trust as it is. But if you have an investment property, you have to do it with fractional deeds. And you have to keep it under the certain dollar amount as you transfer the deeds on a regular basis until the entire value has been transferred into the irrevocable trust. And there are different types of irrevocable trusts. There are irrevocable trusts that hold insurance policies. We often do that when people have very large estates. And when you have an insurance policy, that's considered part of your estate. So if you have $1 million insurance policy that you're paying the premiums on, for estate tax purposes, that $1 million payout is part of your estate and thus subject to the estate tax. So, but when we do insurance trust, oftentimes we do it to decrease the value of the estate so that it stays under the estate tax threshold. And as I said before, currently that estate tax threshold per person is $12,060,000. But again, it's going to revert in the year 2026 to $5,000 with plus the cost of inflation may impact that. But the insurance trust is often used to pay the estate tax for very large estates. Okay. So since it's out of the trust, out of the estate of the person, they can make arrangements with that insurance trust to pay the estate tax. Then there are charitable trusts. Often those are irrevocable. So they're like charitable remainder trust and charitable lead trust. They're trusts called GRATs, where people want to transfer their properties to maybe their children and get a tax benefit and get that asset out of their estate. There are all types of irrevocable trusts, but the overriding theme for those types of trusts is once you create the trust and you fund that trust with assets, you can't ask for it back. theoretically, because there's always a way, right?
Well, if you have an
And,
attorney, there's always a chance to ask.
yes, yes. So if you, even with the irrevocable trust, if you get everybody on board and they say, hey, let's tear this document up, well, you tear it up.
Matt asked an interesting question. How important when somebody approaches you, how more likely to work with them if, in addition to being a real estate agent, they're also an auctioneer or they hold auctions? I know that in LA we have certain types of probates that have to go to auction because they're when the LA County attorney handles the case, that's their format. They use an auctioneer as their service. And I know there are other companies that do that on a retail basis as well. And it's one of those tools in real estate outside of probate that kind of, it's a concept that sounds good once in a while and seems to ebb and flow. Is the auction process important to you? Is that if I came to you and said to you, in addition to being a realtor, I have an auction and here's why that will get you a better price for a client, is that something you're interested in hearing about, or is that just another gimmick to you?
Well, I haven't had much experience with it, but
Okay.
I can tell you that if that were offered to a client, that might be something that would appeal to a lot of trustees.
Nice to know. And
Yeah.
then how important are, say, somebody having a designation such as certified estate specialist or a certified probate expert? Are those kind of, I know with attorneys, there's designations that you get certain privileges and postings on your bar and such with. Are those designations something you pay attention to in real estate agents, or are they not so important?
They're important to the extent that you have the assumption that at least that person has some experience or knowledge.
Okay.
But ultimately, it just comes down to human relationships.
Okay.
Is this somebody that you like and can work with? Are they going to put the energy into to make sure that this client is taken care of?
Yeah, I mean, we as real estate agents, I'm sure attorneys as well, we get marketed all the time by companies and the value of the designation. And people ask me, and I say the value is the education. It gives you the confidence and the ability to give value to your customer. But the designation, you can copy it on the internet and use it fraudulently. You're not going to get any more business. It doesn't really do anything for you.
Mhm.
Question from North Carolina. Linda says she got an email from a realtor that her aunt died in Florida, was looking for relatives. She said she had a son, believed he died, blah, 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 didn't know, hired a PI to search. There's a long story here. I'm sorry you got started on all this. Having said that, well, and the niece is being entitled to anything in the house. Okay. So tax sale in July. So Florida moves, other states move faster than California. And Mr. Hayes is licensed here in California. So other than for sport, he really can't give you an answer on what happens. But this is a common problem in the South in particular, where it was common to have families that have 8 or 10 children, and the next generation had also 8 or 10 children. All of a sudden, grandma, grandpa had like 50 grandkids. And when they pass, if they didn't do an estate plan, all 50 have a fractional share. None care enough to take care of the matter. And there's disputes, and then people buy up bits and pieces of it along the way and take over. Are you aware of this process at all? It's more common in the South. It's not as common here in California, but it's particularly challenging in the rural parts of the South where, in the old days, we all had larger families, and in rural areas, they tend to have larger families. But it's becoming a very big, I think, I don't want to say political issue, but it's becoming an issue of families losing their family airships through these processes. Is this something you're familiar with at all?
I'm sorry, when you say through these processes, what are the processes?
So these are fractional interests. And so what happens is nobody's really in charge. And so taxes don't get paid. And then investors buy up tax sales. And then they become fractional owners, and they force to sell the property. But among the 50 grandkids, none really care to buy the property. So the one guy kind of gets it on, he'll say on the cheap. Of course, the investor would say, well, you could outbid me if you think it's worth more. And so there's a kind of a controversy about, look, this is the after effect of not planning proper estate, as you have these grandparents who worked their whole lives for these properties, and these cases many times farms, where they meant to keep them in their family forever. Maybe they didn't know, or some of these processes like estate planning didn't exist back then. It is sad to see happening, but it's very common. I know in South Carolina, in Georgia, and in Florida, and they're very litigious because you have multiple heirs and multiple attorneys. I'm not sure we could really get into that in detail here today, Linda. It's an important topic, but I don't know that's really quite our topic here today. Maybe we could talk offline sometime. Okay. Yeah, Michelle, you make a good point about that. Okay. Any other questions I see here? I don't see any hands up or any other questions. Anybody have anything else for Mr. Hayes here? I appreciate, the court's been changing so much. You and I met when it was open, and now then it was locked down, and now we're somewhat back open. How do you see the change? Are we going to go back to where we have the more collegial probate bar existence like we did in LA County, or is this kind of the new normal, the mostly online and rarely see your colleagues in person? How do you see that happening?
Well, Bill, as much as I enjoy seeing you, I do like being able to be on court call with a cup of coffee in my hand. So if it stays this way, I'm okay with it. I like not having to go through traffic, park, going to the courthouse. No, I like the new normal.
I will say that I go for an occasional purchase or sale of a property, and those I have to go in person. So I do go about once every 2 or 3 weeks. I put on a suit, tie, get up like a real person, go to work. It is kind of fun once in a while, but I don't miss doing it every day. It's too nice. I can see why you wouldn't.
Yeah.
Well, look, I just want to thank you so much for your time. You and your staff have been so gracious to give your time here today. I know we've recorded some other material with you. And just to kind of a quick recap, so we want to get a hold of you, what's the best way if they have a detailed question or have a client that's looking for an estate plan or they have a probate question, what's the best way to get in touch with you?
They can always call the office and just indicate that they became aware of me through this conversation with you, Bill. Or if they have a question, they can write us at info@losangelestrustlaw.com. Or they can attend one of our webinars on Wednesdays at 6, Saturdays at 10, and we take questions at that time. So the choice is yours. You have alternatives.
Well, look, thanks. I don't think there's any attorney who is as good and consistent about educating their clients as well as prospective clients as you guys are. I really admire it and appreciate it. I'm glad to be part of it today. Thank you so much for your time. And thank you, staff, as well.
The honor of talking to you. I appreciate that.
Oh, great. And for everybody else, this wraps up Probate Weekly. We do this every Thursday, 4 p.m. Pacific. You can sign up at probateweekly.com. We live stream it on YouTube and on Zoom and LinkedIn, YouTube and Facebook and LinkedIn. Feel free to ask questions there. Reach out to me. Appreciate you guys' support. Thanks so much. And